Thank you for listening to The Lawyer's Daughter. This is Jen Carroll, and this podcast does not have any video. I know I'm on YouTube, but that doesn't matter. I really appreciate you listening to the podcast here. Let's go get started. Hello, my friends. It's August 31st. It's day 67. There's only 67 more days left in this campaign. No, 66 days left. We don't have much time. 2 months. It's getting so much closer. It is Labor Day weekend. It is glorious in Santa Cruz. I just went out into the heat. It feels so good. And we're going to talk about the Supreme Court. So this is meant to be a relaxing 3 days of podcasts. We're going to talk about the history of the court today and why it's important for our democracy. Then we'll talk about court cases and how those rulings have been good and bad. And then I was like, how did I say that carefully? And then we'll talk about what is really happening with the court today. Bring it right up to the present, because we've got a lot of issues with the court, and probably Monday will be your juiciest day. But if you don't understand the Supreme Court, or if you've just been curious, hopefully these two podcasts will give you some more information. And they're definitely pro-democracy pods. I mean, everything I write is pro-democracy. And that means, yes, that means access. That means freedom. That means life, liberty, and the pursuit of happiness. How's that? Just like George Washington wanted. So the Supreme Court is one of the three branches of government. We know this. We talk about it. There's the executive branch led by the president, the legislative branch made up from Congress, and then, of course, the judicial branch, which is under which the Supreme Court falls. And each branch has a unique job. So the Supreme Court's job is to interpret the laws of the land. Interpret the laws of the land, ensuring how they follow the Constitution. Which is why you may hear some people say, oh, they're a strict constitutionalist or not. It means how much they're willing to allow progress. That's a good word for it. How much they're willing to allow progress to help influence laws as they interpret them today. I happen to be a living, breathing Constitution person, and I don't think it's about going back to what it was said literally, but it was to get the intention of the law. And I do believe the intention behind the Constitution is very straightforward and very clear. So there you go. Go have a debate with somebody about how you think laws should be interpreted. That's its own hot mess. But I just cannot believe in being a strict constitutionalist in terms of being literal, because it just couldn't know all the things back then. We're talking about the 1700s. 1789, I believe, is our popular year. And it's going to come up again in just a minute. So the responsibility that this court has, the Supreme Court, is a crucial part of our democracy because it helps maintain the balance of power between the government and the people. That's how this works, guys, just so you all wonder. Democracy is really about self-governing. And if you don't believe we're self-governing, we are. Now, there's a lot of things that influence our government, but the thing is, we're still doing it. We, the people, are still managing our own government. It's getting stretched and pushed and leaned on in a lot of ways. That's unfortunate, but it still is something worth fighting for, and it still belongs to us. It's a government by the people, for the people. That is the intent. That was always the intent. So our forefathers, don't know how bad I wanted to call them our forefeathers. Our forefathers believed in a fair and legal justice system was essential. A just legal system, sorry, not a legal justice system, a just legal system. Think about that. A just legal system is essential for a strong democracy. They wanted to ensure that no government branch would be too powerful, and the Supreme Court was created to serve as the final authority on legal disputes, especially those involving the Constitution. By having the court, they hoped to protect the rights of all Americans. So today, the court's made up of 9 justices, including 1 Chief Justice. The Chief Justice leads the court, guides discussions. I'd love to be there for that. Like, okay, everybody, grab a seat. We're going to have a meeting today. Did everybody get a snack? All right, everybody's gone to potty. All right, we're going to have a talk today about a major discussion that's going to change the lives of all women. Sorry, it's like an SNL sketch. We could kind of have some fun there. But he guides the discussions and often writes the big decisions. And I put that in quotes because you have to be a Supreme Court justice to decide what's a big decision. I think we people know what big decisions are, but they seem to have a different way of thinking about it. All the justices work together to interpret the law, making decisions that affect the country. They serve for life, meaning they can stay on the court until they choose to retire, pass away, or under rare circumstances, they are removed. I'm looking at you, Thomas. This lifetime appointment helps them make decisions without worrying about losing their jobs for political reasons. Yeah, see, that's screwed up because they shouldn't. I get we're going to talk about what that means by political reasons, but this doesn't separate if the judges act politically, and that's been the problem. But let's go back. Let's go way back machine. Here, that was my sound effect for going back in time. I think that's what Bert used to do on soap. You're going to have to Google it. That's some old crap right there that I just referenced. In 1789, the year that we have found so many things started, the first presidency, the first speakers of the House, all these things, the vice presidency, these things all came about in these late 1700s after the whole Constitutional Congress, and they birthed the Supreme Court. They passed, in 1789, they passed something called the Judiciary Act, which officially created the Supreme Court. And at that time, this is so cute, the court had one Chief Justice and 5 Associate Justices, and they met first in New York City on February 1st in 1790. Winter, that's still winter. February is not even emerging spring. That's still winter, February 1st. However, the early years were not easy. The justices spent much time organizing and figuring out their role in the new government. They also faced challenges that had to do with asserting their authority, and many were unsure about the court's power. One of the most challenging tasks in the early days was something called riding the circuit. Now, riding, like R-I-D-I-N-G, like giddy up, riding the circuit. This meant the judges had to travel to different parts of the country to hear cases, which was exhausting and, for the most part, dangerous because the roads were rough and the travel could take weeks. Because of these difficulties, some of the justices, like John Jay, the first Chief Justice, resigned. He just refused to return when he was asked to come back again in 1800. Like, nah, that travel, that's just not working for me. Unless you want to get me like something exclusive, I don't know, like an RV maybe. Sorry, Jen, come back. Soapbox. I should kick it back under the table. In 1801, because remember, Chief Justice John Jay, J-A-Y, refused to come back. In 1801, the Marshall Court began, and thus began something called judicial review. So prior to the 1800s, prior to 1801, judicial review wasn't really something that was part of the Supreme Court's responsibility. I'm trying to think of like how to say it. It wasn't something that they thought about every day. But look what happens. You find them in the 1800s coming in, and you have John Marshall appointed as Chief Justice, and he starts to establish the court's authority. So this is interesting. Remember, we're a living, breathing democracy, and so here's this thing, the Supreme Court. Like, what should the Supreme Court do? I don't know. You smart people need to figure it out. Well, here comes John Marshall, who starts to do some things. In 1803, we have Marbury versus Madison. And the people talk about this all the time, because I think if in your law school, this is like one of the cases that you have to etch into your very soul. But Marbury versus Madison is the case that established judicial review, meaning the Supreme Court could declare a law unconstitutional. So this is why Marbury versus Madison is so important, because that finally said a Supreme Court could decide a law was unconstitutional. This has got to be really important because all the time laws are getting made, and if a law is unconstitutional, it's got to go. So this Marbury versus Madison is a huge deal because it gives the court a crucial role in checking the powers. I mean, like it was established to be a power check, but they didn't really know how they were going to do that. This is one of the first ways. Hey, is this new law constitutional? That seems fundamental, and it happened in 1803. So that's pretty early on in the childhood years, the early toddler years of our country, frankly, at 1801. Then we have Marshall also having the court define the relationship between the federal government and the states. Interesting, right? Because these things hadn't really been worked out yet. You have a United States. We start to have some states. We have colonies. Now they're becoming states. They're creating their own constitutions or whatever a commonwealth has. And the court starts defining this relationship between the federal government and the states. And in cases like McCulloch versus Maryland, and I haven't heard of this one before, but it sounds super important. This is in 1819, so it's about 20 years into into the 19th century, the court ruled that federal law is stronger than state law. Yep, federal law, I was going to say, every weed smoker knows that law. Federal law is stronger than state law. That's why you can smoke in California, but you cannot carry it on a plane and you cannot mail it through the mail because both of those are federally regulated. That's what they're trying to do with abortion, which is you can make it illegal in the state, but they're trying to say also if you travel, the feds right now, but the Biden administration is saying you cannot make travel illegal in the United States. I can't even believe we have to say that out loud. Have to say that out loud. But that's the kind of thing we're looking at right now is the way to say to make federal laws that are stronger than state laws. That's McCulloch versus Maryland. That's as old as 1819. And then Gibbons, and I don't believe these were the monkeys, Gibbons versus Ogden in 1824 reinforced the idea that the federal government controls interstate commerce, trade between states. And these decisions help strengthen the federal government's power. So if the government controls interstate commerce, which is, in my opinion, a good thing because it means that the people who get the thing in Nevada can have the same thing in California, can have the same thing in Florida or Washington or Iowa or Kentucky. So, and those things have to be regulated. Yay. That's good. I think that's good. You can decide if you don't like it, but I like it knowing that things can be reliable and trustworthy. Then America starts to grow and the court expands to ensure that laws are protected. As the United States expanded and encountered these new challenges, the court was crucial in addressing the nation's most pressing issues. For example, during the Civil War and Reconstruction, the court faced significant cases related to slavery and civil rights. But one of the most famous decisions, and you know it because you hear it all the time, but you may not really know what it did, is Dred Scott versus Sanford. No T, Sanford. The Dred Scott case is even being brought up right now to try to prevent Kamala Harris from running for president. Let me tell you what Dred Scott's about. The court ruled that African Americans could not be citizens. The decision was widely regarded as one of the worst in the country's history due to its support of slavery and its role in exacerbating tensions leading up to the Civil War. So if you hear Dred Scott cited as a reason why someone can't do something, you need to know that is some racist shit. Because it's the rule that said African Americans could not be citizens. And that's what they're using to try to get Kamala off the ballot. It gives me a headache, people. I don't even know. Like, we have so many important things to do in this country, and this kind of racist garbage just gets exhausting. So guess what? In the post-Civil War era, the court started protecting civil liberties. In Ex parte Milligan, the court, this is in 1866, so now we're getting into the mid-century of the 1800s, the court ruled that civilians could not be tried in military courts when civil courts were available, which is really important because that really reinforced the value of civil justice even during times of national crisis. And I find, as a frequent viewer of SVU, I do find it interesting that there are some entities in our world that don't have to live by the police rules of being like college campuses can get away with doing their own investigations a lot. I say no, that's crap, because there's no way when things are kept private, you don't know what's really going on and you really can't uncover the criminals if you are in private. So this idea of using civil justice instead of military courts, if civil justice is available, is great because it is just more visibility and you can shine a light on it. Anything done in private does not have the kind of transparency. And I'll tell you, every time there's not transparency is when bad things happen, right? So the 20th century, the 1900s, right? Remember, 20th century means the 1900s, brought new economic challenges, particularly the Great Depression, and it added to economic turmoil. Now, this is interesting. I'm going to take you through this section because this is when a court cannot be friends with a president and can really upset a president's administration's vision and mission. And this happened to do with Franklin Roosevelt. And this is actually why we have the checks and balances. It's just sometimes it doesn't work very well. Franklin Roosevelt introduced the New Deal. This is mid 19th century, right? Just after the Great Depression. So we're like in the 30s. A series of programs and reforms were in the New Deal aimed at revitalizing the economy and providing relief to Americans. However, The Supreme Court, dominated by conservative justices, was initially resistant to expand federal powers. Several key places of the New Deal were struck down. One was about it's the case is funny. It's Schechter Poultry versus the United States, but this had everything to do with allowing the president to regulate an industry to stabilize prices and stimulate recovery. That's super relevant to right now. So in the New Deal, Roosevelt had proposed a law that would allow him to regulate and stabilize prices and stimulate recovery. And the court ruled it was unconstitutional to do that as part of the executive branch. That kind of power belongs to the legislative branch, is what they said. And so they did not allow the president to stabilize prices and stimulate the recovery. That may or may not have been a good decision, but they pushed it to the legislature. If the legislature supported their president, they could go ahead and make that pass. And then there's the United States versus Butler. The court declared that the Agricultural Adjustment Act was unconstitutional. That act was trying to raise agricultural prices by reducing crop production, and it was funded by taxes, so that they wanted to do this to try to control the outrageous costs. And the court ruled that this use of federal spending exceeded constitutional limits, and it complicated Roosevelt's efforts to stabilize the economy. So because of those rulings, it led to a significant conflict between the Supreme Court and Roosevelt, who felt the court was obstructing reforms. Roosevelt proposed the court packing plan in 1937, which aimed to add more justices to the Supreme Court who would favor his policies. Sounds a lot like our other friend. The plan was controversial and ultimately failed. There you go, it failed. That's what it should do. It should fail. You should be allowed to pack the court. And it underscored Roosevelt's frustration with the court's resistance. As the composition of the court gradually changed, though it did, its stance softened, and it led to some key rulings that supported the New Deal. For example, there was something called the West Coast Hotel Company versus Parrish, and this was a turning point when the court upheld Washington state's minimum wage law for women, reversing earlier rulings against such regulations. So this decision was known as the switch in time that saved nine, because it indicated that the court was finally ready to start accepting some government regulation in the economy, particularly concerning labor rights. So there you go. We finally saw minimum wage approved for women. And then we had NLRB versus Jones and Laughlin Steel. And this was in 1937. And this is when the court upheld the National Labor Relations Act, which protected workers' rights to unionize and bargain collectively. The court ruled that labor relations could affect interstate commerce and fall under federal regulation. That's how they decided workers' rights fit. It's under the interstate commerce laws. And this decision was a big victory for the New Deal and solidified the federal governor's role in managing economic and labor issues. So interestingly enough, I just thought this New Deal history was interesting because Roosevelt had the court that didn't want to play with him and didn't want to support him. And then if we could just wait a little bit, it changed. I will say, though, I'm not sure that will save us right now, because we didn't have anything of the kind of corruption and nonsense going on then that we have going on. There was some. There's always some, right? Everybody always has an agenda, but it's nothing as sophisticated as what we have now. So if we look now in the Supreme Court entering the 21st century, right? That's us. That's now. And I put in here, it's entering the 21st century, kinda, because they're coming in like a hot mess, just such a hot mess. But let's talk about how it's coming in. In the Supreme Court continued to evolve after the New Deal. So now we're in the 50s and 60s, right? It's playing a significant role in advancing civil rights. One of the most famous cases during this time was Brown versus the Board of Education. It declared racial segregation unconstitutional. So there's your two. Dred Scott, bad. Brown versus Board of Ed, good. Dred Scott supports racism. Brown versus Board of Education removes segregation. Very big deal. It was a significant victory for the civil rights movement and helped pave the way for further progress. More recently, the court faced new challenges brought about by changes in technology. In Riley versus California, The court ruled that police need a warrant to search someone's cell phone, recognizing the importance of digital privacy in a connected world. Well, that's one. And in Obergefell versus Hodges, the court, this is a good one. Obergefell is a good one. The court made another landmark decision by legalizing same sex marriage, reflecting society's evolving attitudes. So there's another good one, Obergefell. You hear that one a lot. When you hear the Obergefell, that's gay marriage. Okay, that just means you can marry the person you love. That's nice. However, as the Supreme Court steps further into the century, it's not just legal challenges that loom on the horizon. There are growing concerns about the integrity and transparency of the court itself. And with this increasing scrutiny of the actions and associations of some of these justices, the questions about ethics and impartiality are beginning to surface. So, y'all should know about this already, that there is a lot of questions about the ethics and the impartiality of our justices. Literally, I took that for granted. I did know people came with a bias because I'm not stupid and humans always have a bias. But I actually thought the goal was for these Supreme Court justices to hold themselves to an incredibly high standard. I mean, we talked about the court a lot in my house as a kid, and I understood them to be the most stand-up Americans on the planet. Like I said, they might have a bias for what they believe, how they believe things should work, but it didn't matter because they would use their brains and their logic to help make these rulings. And alas, my heart has been broken because that hasn't happened very, very recently. The Supreme Court is essential for democracy, and understanding its history is really good for helping us understand how the decisions it's making today will continue to impact our lives. It's evolved from a small, uncertain body where it had to figure out what its charter was, and it's become one of the most powerful institutions in the United States. And it really does help maintain the balance of power within the government. But we'll talk about that in some of its recent rulings and how even it's giving up a little bit of its power, which is kind of worrisome. It's the ultimate interpreter of the Constitution, and it protects the rights and freedoms that define American democracy. So as it continues to navigate, the court continues to grow and navigate and pull its head out of its collective issues butt right now, because it's got a lot of problems with integrity. I think it's got the lowest public support numbers ever. That's bad. It's one of the most powerful institutions in our government, one of the three branches of our government of power, and we don't believe that they are capable of running and doing their jobs without political influence. That's what I have for today on the short history of the Supreme Court, just to give you an idea of how it's grown and how it's found its way and what it's here to do. And then tomorrow, we're going to get into some of the most incredible court rulings that have shaped who we are as a democracy. A little bit will be what we talked about today, just a little bit, but most of these cases, they're really worth looking at and understanding how those rulings went down. So come back tomorrow. We'll all say rabbit, rabbit for the first day of the new month, and we'll talk about the court rulings that have shaped our democracy. Thank you for listening. Thank you for listening to today's podcast. Make sure you subscribe and rate, and I'll be back with another episode really soon.